Hi everyone, I'm Vita Delisi, and in this video we're going to talk about the risk for sellers when serving an N12 notice for a buyer. Well, we provide legal support to realtors and your landlord and investor clients when you're purchasing and selling tenanted properties. However, you need to know that the N12 notice is a 60-day notice for the landlord or new purchaser's own use. However, it's not just a notice, because the N12 comes with very strong cost consequences and requirements. The misuse of an N12 can lead to a T5 bad faith application, meaning landlords, one of the requirements of the N12 notice is that it must be served in good faith with clean hands. And what that means is that landlords should not serve an N12 because they're experiencing problems with that tenant. They don't like the tenant's being disrespectful, they've blocked you from WhatsApp and WeChat and Facebook Messenger, and they're not answering your text messages on time. Whatever the case is, the N12 must be served in good faith. Otherwise, it can lead to misuse, and misuse can result in a T5 application. Let's talk about that. A former tenant can file a T5 bad faith application against their former landlord within 12 months from the date that they moved out. That's right. This is not something that they can think of doing in 7 days or 30 days or even 6 months. They have 12 months from the date to move out, that they moved out, in order to pursue a T5 application. And in doing so, they can sue for up to $35,000 through the Landlord and Tenant Board. The reason why it's up to $35,000 is because that is the monetary jurisdiction of the board. Suing for anything higher than that, the tenant must go to a higher court. There are certain remedies that a T5 entails. Here are remedies that a tenant can sue for. Number 1, a rent abatement. Number 2, the rent difference from their former rent to their new rent times 12 months. Number 3, their full rent. That's right, their full rent, the rent that they lost times 12 months. Number 4, any moving costs or storage fees. And number 5, any fine that the board deems appropriate. And it's in this number 5 remedy box where oftentimes tenants want the board to fine the realtor. So make sure you get legal advice before serving an N12. And guys, as agents, please don't get involved with drafting, serving, filing of an N12 notice, because if something goes wrong, you take on the liability. I hope you found this video informative. If you have any questions, call us first.